Question number 401. On the reversal of decree, which section imposes an obligation on the party to the suit who received an unjust benefit of the erroneous decree to make restitution to the other party for what he has lost? Here correct answer is option D, that is section 144 of CPC. Question number 402. Which one of the following sections of the CPC embraces the principle of restitution? Correct answer here is option B, that is section 144 embraces the principle of restitution. Question number 403. What is the meaning of restitution? That is section 144 CPC. Here options are option A, dispossessing a person in occupation of suit property, option B, re-adjudication of the claim, option C, restoration of suit, and option D, restoring to a party on the modification, variation or reversal of decree. Here correct answer is option D, that is restoring to a party on the modification, variation or reversal of decree is known as restitution under section 144 of CPC. Question number 404. Right to lodge a caveat has been provided under. It is provided under section 148A of the CPC. Question number 405. By which of the following act section 148A, that is right to lodge caveat, was inserted in the Code of Civil Procedure 1908? It was inserted by the Act 104 of 1976. Option C is the right answer. Question number 406. The duration of existence of a caveat filed under CPC is 60 days from the date on which it was filed, 30 days from the date on which it was filed, 120 days from the date when it was lodged, and option D, that is 90 days from the date when it was lodged. Correct answer here is option D, that is 90 days. Question number 407. A caveat under CPC may be lodged when any, option A, suit is instituted, option B, proceeding is initiated or instituted, option C, suit is about to be instituted, option D, suit or proceeding is instituted or about to be instituted. Here correct answer is option D, that is suit or proceeding is instituted or about to be instituted. Question number 408. Lodging of caveat under section 148 of CPC, option A, entitles the caveator to receive notice of application, option B, makes the caveat or a party to the suit, option C, both A and B, and option D, none of the above. Here correct answer is option A. Lodging of a caveat under section 148 of CPC entitles the caveator to receive notice of the application. Question number 409. Under which section of the CPC inherent power of the court has been provided? Here correct answer is option A, that is section 151. Under section 151 of CPC, inherent power of the court has been provided. Question number 410. Inherent power may be used by the court for option A, meet ends of justice, option B, to prevent abuse of process of the court, option C, both A and B, and option D, none of the above. Here correct answer is option C, that is both A and B, meet the ends of justice and to prevent abuse of process of the courts. Question number 411. Under section 151 of CPC, inherent power can be exercised by the Supreme Court, High Court, District Court, any court. Correct answer here is option D, that is any court. Inherent power under section 151 CPC can be exercised by Supreme Court, High Court and District Court. Question number 412. In which of the following cases it was held that inherent power has not been conferred on a court? It is the power inherent in the court. Here option A is the right answer, that is Manohar Lal versus Seth Hiralal. Question number 413. Inherent power conferred under section 151 of the CPC may be exercised by the Supreme Court only, High Court only, District Court only, Supreme Court, High Court, District Court, as well as by any civil court. Here correct answer is option D. Question number 414. In which one of the following cases it was held that inherent power has not been conferred on a court? It is the power inherent in a court. Here correct answer is option D, that is Manohar Lal versus Seth Hiralal. Question number 415. Under the inherent powers of the civil court, it can pass orders, option A, to refer the matter of mediator, option B, necessary for the ends of justice or to prevent the abuse of the process of court, option C, for compelling the parties to settle their case, and option D, for compelling a plaintiff to withdraw his suit. Here correct answer is option B, that is necessary for the ends of justice or to prevent the abuse of the process of the court. Question number 416. Affidavits to be filed in a court can be authenticated by the Minister of State, cannot be authenticated except by the judge presiding, authenticated by a judge, a magistrate or a notary, and D, authenticated by an advocate. Here correct answer is option C, that is authenticated by a judge, magistrate or a notary. Question number 417. All orders and notices served on or given to any persons under the provisions of CPC shall be in writing has been provided under option B, that is section 142 of CPC. Question number 418. Section 148 of CPC, court can enlarge the time not exceeding in total. Correct answer here is option D, that is 30 days. Question number 419. Time for instituting a suit can be enlarged by invoking which of the following provisions? Option A, section 151 CPC, B, section 5 of Limitation Act, C, section 148 CPC, and D, none of the above. Here correct answer is option D, that is none of the above. Question number 420. Where any period is fixed or granted by the court for doing an act prescribed by the Code of Civil Procedure, the court may enlarge such period. Here correct answer is option B, that is not exceeding 30 days in total. Question number 421. Clerical or arithmetical mistakes in judgments, orders, etc. can be corrected under. Correct answer is option A, that is section 152 of CPC. Question number 422. The power of a court to correct clerical or arithmetical mistakes in judgments, decrees, or orders may at any time by the court of its own motion may at any time be exercised on an application by any of the parties, either A or B, and none of the above. Here correct answer is option C, that is either A or B. Question number 423. Who has the right to make an application for amendment of judgments and orders under section 152 of CPC? Here correct answer is option C, that is any of the parties. Person aggrieved with the permission of the court. Question number 424. Section 152 of the CPC empowers the court to amend judgments, decrees, or orders in respect of clerical or arithmetical mistakes only, accidental slips or omissions only, both A and B, and none of the above. Here correct answer is option C, that is both A and B. Question number 425. General power to amend any error or defect in any proceedings in a suit vests in the court by virtue of. Here correct answer is option B, that is section 153 of CPC. Question number 426. Which of the following deals with power to amend decree or order where appeal is summarily dismissed in the Code of Civil Procedure? Here correct answer is option D, that is section 153A of CPC. Question number 427. Which one of the following sections of the CPC provides for the trial in open courts where public may have access? Correct answer here is option B, that is section 153B. Question number 428. Under the provisions of CPC, the court has no inherent jurisdiction to restore a suit dismissed for the non-payment of court fees, to restore an election petition dismissed for default, to consolidate suit based on different claims, and option D, all of the above. Here correct answer is option D, that is all of the above. Question number 429. When proper court fees is not paid by the plaintiff, the court shall, option A, reject the plaint, option B, shall grant time to the plaintiff to pay deficit court fees, and option C, the court shall send a report to the government, and option D, none of the above. Here in question number 429, correct answer is option B, that is shall grant time to the plaintiff to pay the deficit court fees. Question number 430. Which provision of the CPC provides that one person may sue or defend on behalf of all in the same interest? Correct answer here is option C, that is Order 1, Rule 8 of CPC. Question number 431. A suit in representative capacity can be filed by the virtue of. Correct answer here is option C, that is under Order 1, Rule 8 of CPC. A suit can be filed in representative capacity. Question number 432. Representative suit under Order 1, Rule 8 of CPC may be permitted by the court when numerous persons are parties in another suit, numerous persons belong to the same family, numerous persons have the same interest in one suit, none of the above. Here correct answer is option C, that is numerous persons have the same interest in one suit. Question number 433. With respect to the suit under Order 1, Rule 8, choose the true statement about the propositions. First, all members of the class should have a common interest in the subject matter. All members of the class should have a common grievance in the subject matter. The relief sought in its nature be beneficial to all. Assertions first and second are correct, third is incorrect, second and third are correct, first is incorrect, first and third are correct, second is incorrect. Here correct answer is option D, that is all are correct. Question number 434. Which one of the following is not required in filing a representative suit under Order 1, Rule 8 of the CPC? Options are numerous parties, same interest, leave of the court, written permission of those who are being represented. Here correct answer is option D. Written permission of those who are being represented is not required in filing a representative suit under Order 1, Rule 8 of CPC. Question number 435. Which is the case of which notice to all persons interested in a representative suit need not to be given? Option A, abandonment of the suit, withdrawal of the suit, recording of the compromise in a suit, addition of a new defendant in a suit. Correct answer here is option D, that is addition of new defendant in a suit. Question number 436. A suit filed in representative capacity can be withdrawn, compromised and abandoned etc. by the plaintiff. Option A, without notice to the all persons interested, after notice to the all persons interested, both A and B, either A or B. Here correct answer is option B, that is after notice to all the persons interested. Question number 437. Under the Code of Civil Procedure, where a person who is necessary party to a suit has not been joined as a party, it is a case of misjoinder, non-joinder, both A and B, none of these. Here correct answer is option B, that is non-joinder. Question number 438. On account of misjoinder or non-joinder of the parties under Order 1, Rule 9 of CPC, the suit is liable to be dismissed, cannot be dismissed, may be dismissed or may not be dismissed as per the discretion of the court, none of the above. Correct answer is option B, that is cannot be dismissed. Question number 439. Question number 439. A suit may be defeated due to non-joinder of a party, proper party, misjoinder of a necessary party, non-joinder of a necessary party, misjoinder of a proper party. Here correct answer is option C, that is non-joinder of a necessary party, a suit may be defeated. Question number 440. Under CPC, where a person who is necessary party to the suit has not been joined as a party, it is a case of misjoinder, non-joinder, both A and B, none of the above. Here correct answer is option B, that is non-joinder. Question number 441. Under which provision of CPC the parties can be struck out, added or substituted? Correct answer here is option B, that is under Order 1, Rule 10. Question number 442. A necessary party is one whose absence no order can be made effectively. Absence and order can be made, but whose presence is necessary for the complete decision of the case. C, only B is correct, and option D, none of the above. Here correct answer is option A, that is absence, in whose absence no order can be made effectively. Question number 443. Mark the incorrect statement in context of the representative suit. Option A, if a person suing or defending does not proceed with due diligence, the court can substitute in his place any person having the same interest in the suit. B, the suit can be withdrawn, compromised or abandoned by the plaintiff after giving notice to all the persons interested. Any decree passed in such a suit is binding on all the persons interested. Res judicata is not applicable to such suit. In question number 443, correct answer is option D, that is res judicata is not applicable to such suit is incorrect statement in this context. Question number 444. Where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the proposition so omitted or relinquished. The genesis of this principle lies in option A, Section 115 of the Indian Evidence Act, Section 11 of the CPC, Order 2nd Rule 2 of the CPC, Order 1 Rule 2 of the CPC. Here in question number 444, correct answer is option C, that is Order 2nd Rule 2 of the CPC. Question number 445. As per Order 2 Rule 1 CPC, every suit shall, as far as practicable, be framed as to afford ground for final decision, to prevent further litigation, both A and B, none of the above. Here correct answer is option C, that is both A and B, afford ground for final decision and to prevent further litigation. Question number 446. Order 2nd Rule 2 of CPC does not apply to option A, application for execution, writ petitions, both A and B, none of the above. Here correct answer is option C, that is both A and B. Order 2nd Rule 2 of CPC does not apply to application for execution and writ petitions. Question number 447. With regard to applicability of the Order 2nd Rule 2 of the CPC, choose the true statement about propositions. Propositions. The cause of action in the previous suit must be identical to the subsequent suit. Relief sought in the subsequent suit could have been given in the previous suit. If the omission as to the relief in the previous suit was with or without leave of the court, subsequent suit will be barred. Here, correct answer is option A, that is first and second are correct and third is incorrect. First and second assertions are the cause of action in the previous suit must be identical to the subsequent suit. Relief sought in the subsequent suit could have been given in the previous suit. And third assertion is incorrect. Question number 448. According to Order 2 Rule 3 of CPC, a plaintiff may unite in the same suit several dash against the same defendant. Here correct answer is option C, that is cause of actions. According to Order 2 Rule 3 of CPC, a plaintiff may unite in the same suit several causes of action against the same defendant. Question number 449. A lets a house to B at a yearly rent of rupees 500. The rent for the whole of the year is 1905, 1906 and 1907 is due and unpaid. A sue B in 1908 for the rent due for 1906. Option A can afterwards sue B only for the rent due for 1905. Option B, A can afterwards sue B only for the rent due for 1907. Option C, A can afterwards sue B for the rent due for 1905 and 1907 both. And option D, A cannot afterwards sue B for the rent due for 1905 or 1907. Here correct answer is option D only, that is A cannot sue afterwards B for the rent due for 1905 or 1907. Question number 450. A lets a house to B at a yearly rent of rupees 10,000. The rent for the whole of the year is 2006 to 2008 is due and unpaid. A sues B in 2009 only for the rent due for 2007. Here correct answer will be A cannot afterwards sue B for the rent due for 2006 or 2008. Option D here is the right answer.